All rise. Supreme Court is now in session. Please be seated.
We now take up the third case on today's docket, Craven versus the state of Florida. Counsel?
Yeah. Reservation for a reserve 5 minutes for rebuttal. I would like to focus my argument on issue 2. If you have any questions on issue 1, yeah, proceed to issue 2. Please controls the issue here. This is a control case. This case, a juror said initially he would automatically vote for the death penalty if premeditation was proven.
Counsel, didn't he, we've seen other cases where people were unequivocally, the counsel would try to rehabilitate them, but the initial statement was something pretty emphatic about if it's premeditated then the person deserves death. In this case, it seemed like the juror immediately talked about, he talked about premeditation gets death, but then he said, if there were things about the person's background or mitigating factors. He almost brought that up himself right away. This doesn't strike me as your typical situation where a juror starts off at a certain level and then has to be, brought back by counsel.
Yes, sir. But that's why we have peremptory challenges. It was not a cause challenge. I think the argument was the board had been a cause challenge. This was a peremptory challenge.
I think, though, the issue, though, at least for me, the question is reading in context what the trial court here said. It seemed like it was making a genuineness determination in the sense that, you have your facially race-neutral reason that's given, but it seemed to me that I read what the trial court was saying was that the trial court itself, having observed what the juror said in context, that he essentially didn't credit, it wasn't that he was treating it as a de facto cause challenge, but that he essentially didn't credit the reason because the court itself took into consideration what the juror had said and essentially, discounted that, essentially implicitly was saying that it was a pretextual reason that was being given.
Okay, I understand what you're saying. However, he points out, as in this case, the state did not raise pretext at all. Neither did the trial judge mention that the reason given was pretextual. I peremptory challenge. The inquiry is whether it's pretextual, whether there's purposeful intention, not whether it's factually correct or incorrect.
There was a prior juror, if I remember correctly, who was fairly adamant at first that premeditation would equate with a death sentence in her mind, correct? And with respect to that juror, she was rehabilitated, and there was a cause challenge that was denied, correct?
If I remember correctly, that one was granted. Cause challenge was granted on Johnson. You talking about a female juror Johnson?
I thought there was one that said something that indicated there was that if the murder was premeditated, they would tend to vote for death. There was a cause challenge that was denied, and then there was no peremptory exercised with respect to that juror. Am I misremembering the record?
I will have to go back and look. But the state did not argue what you're talking about. The trial flow. So
Was that juror forehand?
I think so, yes, sir. And I read the state did not raise the argument at trial about this peremptory challenge. So I don't see how you can consider that wasn't raised by the state, neither at the trial or in the brief.
Counsel, if you set aside our precedent on this and just look at it kind of fresh, why, even if we assume that there was an error here, why would this not be subject to harmless error review?
Because it takes a unanimous vote for death. And one juror is swayed towards the death penalty, it can affect or influence undecided jurors.
But in this case, though, the premise is that the juror was not, that a cause challenge wouldn't have been warranted. And so what's the prejudice? What's the harm?
The answer is that the juror served on the jury. He was not on justice. This is a constitutional right to exercise peremptory.
There's not a constitutional right to peremptories, though, right?
There is yes, it says there is a constitutional right to exercise peremptories. This amendment right to a fair trial. Originally, we have peremptory and that each side can challenge jurors who are perceived not to be in the best interest of our for any reason. And if the opponent of the strike retains the burden of proof to prove pretext, then on this issue, I will argue that his controls and under his remain for a new trial. Are there any other questions? Any questions on the permitted issue? I realize I answered for your decision and if there are no remaining questions, I remain your time for my proposal.
Good morning, may it please the court. Michael Kennett for the state of Florida. This is a prison murder committed by an inmate who had served less than 1 year of a life sentence for a first-degree murder he previously committed. There's no question that the appellant is the one who committed this murder. There are multiple confessions. He was the only one who had the opportunity to kill his cellmate, and there's DNA blood evidence that confirms he is the killer.
Going to the peremptory challenge issue, the juror basically initially said that if it's premeditated, is almost automatic death penalty. Maybe I'm overstating it, but the gist of what he was saying is that. Isn't that, we're not talking about a cause challenge. The juror could have been rehabilitated and the cause challenge could have been denied. We're talking about whether the defense counsel had a reasonable fear that this juror would not be fair. Wasn't that enough for a peremptory challenge?
No, it's not.
What else?
The issue, with regard to issue 2, the real issue of issue 2 is step 3 of the Melbourne inquiry, and that is the genuineness inquiry that the trial court made based upon the argument of the state. And if you look at what happened in this case, step 1 of the Melbourne inquiry, the state is the opponent of the challenge. The defense is the proponent of the peremptory challenge. The state says, hey, we have a concern here. We'd like to see a race-neutral reason for this. Juror Ford, the juror in question, is African-American. There are not just racial undertones to this case, but there are significant racial overtones. The defendant said he wanted to commit a race riot. Right? He wanted to kill his African-American cellmate in part to initiate a race riot in prison. Clear racial overtones in this case. So the state satisfies step 1 of the Melbourne inquiry. We proceed to step 2. The burden of production shifts to the defense. The defense says, well, here's our race-neutral reason. He has an inflexible attitude towards the death penalty. That satisfies step 2. Now we go to step 3. But what's interesting about that response is it caught the court's attention. And when the court says, well, you didn't raise a challenge for cause yesterday, the court wasn't conflating challenges for cause with peremptory challenges.
Well, let's go back. You said that the defense said that the juror had an inflexible attitude toward the death penalty.
I paraphrase, Justice Kennedy.
Well, that is a paraphrase, because what he said, he was what counsel actually said. He was one of those who, though rehabilitated to say he could consider life or death, he was one of those whose original impulse was if it was found to be premeditated, then it would be the death penalty, and that's my concern with him. Isn't that statement by counsel a statement that is absolutely supported by the record?
No, because it is not factually accurate. And that is what...
How is it inaccurate?
It's too strong of a characterization of Justice Ford's initial response. And the prosecutor pointed out the differences between Juror Ford and Juror Glisson, and they were back-to-back jurors. Juror Glisson did display
But Juror Ford said, well, if it's deserved, for instance, if he had premeditated, just did it, yes, the death penalty. I'm struggling to see how what counsel said about that is not accurate.
Okay.
Well, I mean, I'm reading it here. I mean,
right.
we have the benefit of a transcript.
We do, and so that initial response, though, is 2 sentences. It's not just 1 sentence. Juror Ford didn't just say, if it's premeditated, then death. He also talked about mitigation when he talked about influence. But if we pick apart the first sentence, Chief Justice Kennedy, he didn't just say premeditated. He actually, for someone who has no legal experience, Juror Ford gave a pretty good, accurate definition of the law in Florida. He says, well, if, right, that word if, it's conditional. if it is deserved. What he's essentially saying that in his mind, death is not
Well, but he
automatic.
says if it is deserved, for instance,
Right?
if he had premeditated, just did it, yes, the death penalty. Okay? For saying it, so he's giving premeditated, just did it, as an example of what is if it's deserved. I think that's the only fair way you can read that.
Right. He's saying CCP. Because if you look at, he didn't just say premeditated, he said just did it. For someone with no legal experience, that's a pretty good layman's definition for cold. It's unprovoked. He just did it very coldly, very calmly. So what Juror Ford is saying is if the default is not death, he's essentially saying the default is life, it has to be deserved, for example, if there is CCP. That is a very good layman's definition.
Well, I don't know. I mean, you're equating cold, calculated, premeditated with just did it. That seems to me to be a bit of a stretch.
But if we look at the definition of cold, calculated, premeditated, it's not a stretch. It's an unprovoked murder. It's done coldly, calmly, without any resistance from the victim. Just did it. Again, he didn't.
You know, when I read this, I just wonder if the trial court was confusing a peremptory challenge with a for cause challenge. Because and the court even says, well, what would give you pause today that wasn't there yesterday? As though there's a suggestion there that if a for cause challenge is not made, then somehow it's inappropriate to have a peremptory challenge, or that somehow there's something sinister or pretextual about a peremptory challenge if there's not been a for cause challenge. Is that what the law is?
No, but again, it is part of the totality of the circumstances that goes into step 3, which is a trial court making an analysis of whether or not the proffered reason is genuine or not. And to go to a point that Justice Lawson made.
Where do we, what in anything that the trial court said, do we actually see any indication that the trial court was focused on genuineness?
Well, no magic words are required. Hayes clearly says that. But he refers to his notes, and he says, you know, my notes don't support what you just said, which, let's draw a contrast to another juror, and perhaps, Justice Lawson, you were referring to Juror Sims. In the state's brief, the state mentions Juror Glisson. Juror Ford does not mention Juror Sims, but page 433 of the record, right? Juror Sims, first answer, I'm a firm believer in the death penalty. That was his expression. There are two Juror Sims, a Mr. Sims and a Miss Sims. I'm referring to the Mr. Sims, Juror 35. His first answer, I'm a firm believer in the death penalty. He's asked by defense about that firm believer in the death penalty remark. And he's asked, does that mean it's automatic? And he says no. Now, the defense did file a challenge for cause as to Juror Sims, which the trial court denied because the juror had been rehabilitated. And what the court does, he refers to his notes. He says, this is on page 457 of the record. My notes reflect that while he did initially say a firm believer in the death penalty, he did in fact say not automatic, and that was he was not dissuaded from both of those positions despite counsel's questioning. So I'll deny the challenge for cause as to Sims. Now, it's interesting to note that while a challenge for cause was lodged against Sims the previous day, there was no peremptory. Now, we don't know clearly what the racial background is of Juror Sims, but that goes to the trial court's concern about, is that answer that you just gave me really genuine? Because you did lodge a challenge for cause for Sims, but there's no peremptory today, and if I take you at face value, why didn't you do the same thing? If you're really concerned about this particular juror, Juror Ford, having an inflexible attitude towards death penalty, why didn't you challenge him yesterday like you did Juror Sims? And that goes to, again, the trial court's genuineness determination, his credibility determination, and we should defer to that because the trial court was the one who was there throughout the entire voir dire proceedings. He was the one who was able to watch the demeanor not just of the potential jurors but of counsel as well, and we should defer to that determination. There's no indication that his decision was clearly erroneous.
Could you address the harmless error issue? I understand what our precedent is, but just taking it taking a fresh look at it.
You raise an excellent point because as to the appellant, there is no constitutional violation here. Potentially, there could be a constitutional violation involving a peremptory challenge, but not in this case.
But there can be harmful error that is not a constitutional violation.
Yes.
Correct?
Correct, but there's no evidence that this juror was biased for or against.
Well, okay, so you're saying we basically ought to treat, at the trial level, we ought to treat it the way we do on post-conviction?
There's some value in that, because why overturn a conviction where there is overwhelming evidence of appellant's guilt? There's no question that the appellant committed this offense. He conceded guilt as to second-degree murder during his opening statements. The whole issue was mental state and mitigation. But we have 4 very powerful aggravators in this case. He's serving a life sentence when he commits the murder. We have a prior capital felony, the other murder, HAC and CCP. The HAC is horrendous in this case. The victim was attacked when he was asleep. He was at least a dozen stab wounds to the upper body with another 18 superficial wounds. He choked and drowned in his own blood, plus he had blood coming out of his jugular vein. An inmate 2 cells down heard him crying for help. There's clear HAC, there's clear CCP. He planned this murder out. He called his mom and said, "You got to come visit me this Saturday, because if you don't, it's going to be several years."
What about what counsel said, that all it takes is one juror to require a life sentence?
It's too speculative. If you look at what the standard is what would a rational jury do, right? And if the evidence is overwhelming, what would a rational juror do in this case? Convict and sentence to death. That is the standard. It should be the standard. It's a federal standard. What is a rational juror going to do?
Well, but and fundamentally, we start from the premise that this isn't a biased juror.
Right.
Right? One biased juror would be a problem, but in this case, we're talking about a juror who, by definition, because the cause issue has been taken off the table, there's no bias issue.
Correct, and there's no constitutional violation in this case as to the defendant. There could be, in some cases with the peremptory challenge, there could be a constitutional implication. If, for example, the defendant is a member of a minority and the state is attempting to peremptory challenge a member of a minority, the same minority, and that would be the only person on the jury pool, and it was for a pretextual reason, yes, there could be a constitutional implication for that defendant, but there's no constitutional implication for this defendant in this case. So, again, what's the harm? What is the harm in this case? There is no harm. Because any rational juror would have found this particular defendant guilty and would have sentenced him to death. It's a gruesome murder. There are no questions about any of the aggravators. And again, back to your point about what is the remedy, there should be some harm in this case, and there's not. Because there's no harm, there should be no overturning the conviction in the sentence. And back to your point, I think, Chief Justice Kennedy, that the trial court did not conflate peremptory challenges with challenges for cause. He was probing the genuineness of the answer given by the defense. Are there any other questions about any other issues that were raised in this case? There were several issues raised. I briefly touched on sufficiency, HAC, CCP. Proportionality is not an issue in this case. We can discuss proportionality. There are also issues raised regarding the competency to proceed pro se, whether the evidence of the prior felony murder was relevant during sentencing. It was. It's part of the juror's function. How can the juror weigh aggravations and aggravators versus mitigators if it can't know the facts surrounding a prior murder? The state asks this court affirm both the judgment of conviction and sentence in this case. There really is no harm. There is no constitutional violation. There's no basis for reversal.
First of all, there is harm because the facts of the case did not control the issue. The issue is about my client's right to fair trial. My opponent's argument about the aggravators, well, the jurors tasked with weighing aggravators versus mitigation. So yeah, there might be several issues, but there was certainly a lot of mitigation in my final background. Nevertheless, that does not come into the court's decision on this issue. As with deference to the trial court, this court wrote that despite the need of appellate courts to defer to the assessment, this court has recognized that it can't be a rubber stamp on the trial court board. And to clearly erroneous standard, if the trial court based its decision on vastly erroneous version of events, which it did, then the court cannot simply defer to the court. The other point I would make is that there was no argument at trial court on the appellate brief as it were since. I don't see how you can consider an argument that was never raised and that is not before the court. The only issue is issue 2, Juror Ford, and whether the court errs in denying that peremptory challenge. We would ask the court to reverse and remain for new trial. Any questions? Thank you.
We thank you for your arguments. We now will move to the final case on